Cindy's going to talk for a little while on title search stuff. Let's get kind of here. Okay, on last week, there was a lawyer in town for a case. And it was somebody else that's... how many of you were around for the Mickey thing, the kind of... Okay, basically what happened was, I've been doing this for a while. I met a guy from somebody else who was in town to do some other stuff with mortgages a little different way. So I was going to do like this seminar here. It got so big we had to have it in the park. This guy, Mickey Paletta, came. He was in town, so we did it when he was in town. We had people from all over the country, and we even had people from Australia and Europe here. So it was a pretty big deal. I don't agree with a lot of the information that Mickey teaches. I think there's some strong foundation in some of what he teaches. I just don't find it applicable. But one of the guys that had used Mickey for a long time and had some success with some of his stuff, he had a big court case concerning a bankruptcy. So he hired a guy, an attorney here, to handle part of his foreclosure through his bankruptcy and all that. And then that lawyer, I guess, didn't do a good enough job. So that lawyer hired another guy named Michael Pines, who attests to being like one of the leading top 5 attorneys, blah, 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 in the country for doing this foreclosure stuff. So on Thursday was the hearing. We show up at a restaurant. There's way too many people, so we walk over to federal court, and he holds like an impromptu meeting in the cafeteria over at USDC Court. And he talked for quite a while, and my impression was he just doesn't get it. He just doesn't get it. He thinks he gets it. I mean, he keeps saying that he's the best, he's never lost. The banks own the government, they own everything, blah, blah, blah. He's just here to save us. And then it turns out his fees are like $5,000 up front. Whatever your mortgage payment was, half of that per month. Because since you're not paying your mortgage payment anymore, you should have plenty of money. So I know he doesn't get that side of it. And then 40% of the value of your home. So my thing is, okay, so even if you win, you're still going to lose your home. So me and him didn't get along at all. That's putting it quite gently, actually. So I, being my typical moody self, I had to, when it was time to ask a question, if you're an attorney and I show up, don't have a question and answer. So don't. Just skip that segment. Say, John's here, we're going to skip the question and answer thing. So I, of course, asked him about 28 USC 1361. Are you going to hold the judge accountable, blah, blah, blah. He's like, no, because if you got to remember, if we do that, yeah, maybe we might win this one case, but if we have to go in front of the judge again, he's not going to like us, so we're going to lose the next cases. And I'm like,
hello?
Wow, you came up with this right off the top of your head, obviously, because it made you sound stupid. But maybe it was just the truth. So we go to court, and he gets his butt kicked. Just, and I literally just, I humiliated AJ in it too. It was great.
Oh my God.
Well, the whole place is full. The whole place. We got people sitting in the jury box.
Okay.
So I'm sitting down, and AJ walks in. He's going to sit down like a little ways away from me on the bench. So I look at everybody and go like this. And as soon as he sits down, I go, "What?
What did that have to do with the story?
He's the only good part about this story.
That was hilarious. That was a
It
good
was.
one.
It was funny as hell.
Oh my god.
So,
Way to squeeze him.
but this guy, the judge, wiped the floor with this guy.
White?
Oh yeah.
Are you sure?
You don't think so?
White? I think he shredded him on the floor.
Yeah. It was just humiliating. And the attorney had no chance of success. And so afterwards, Doug Rhodes, who's also an attorney that deals in this stuff, who I don't know that there's anything we agree on, and I sure wouldn't want him litigating on my behalf. I'm not sure if he even understands what the word objection means, because I haven't really heard him say it very much. I take him outside and I said, listen, do you understand court? Do you guys get it? He's like, well, and obviously the arrogance kicks in on both. I'm not saying just on his part, kicked in on mine. I pretty much knew this guy was going to get his butt kicked. And I said, we have a rule in Arizona. It's a law. It's a court rule, so it applies as a law. 12-1176. And what it says is, it's Arizona Revised Statute, Title 12, Section 1176, says that if in a forcible detainer, if you request a jury trial, you must be given a jury trial. That's it. Doesn't give any exceptions, nothing. So, here's what I try to tell the attorney, Doug Rhodes, and try to explain to them, and they just don't get it. Okay, does anybody know why they won't give you a jury trial?
You might win.
Because the jurors have more power than the judges.
As you told us, it was prior to facts. They have the facts.
Okay. Everybody's partially correct. Yes, if you have a jury trial, you'll win. Jury really doesn't have more power than a judge. They're supposed to, but it's not recognized anymore. But the jury is the trier of fact. The judge is the trier of law. There's a big difference. When you go to court, the jury is to look at the facts. Now, in law, although the court will always deny it, and if you take any document into court saying otherwise, they will arrest you, the jury can also be the trier of law. They can think that you're guilty pursuant to the facts, but there should be no law. If you went into a courtroom and the jury was all a bunch of leftover 60s hippies that lived to smoke pot,
Yeah.
and I don't know what it is about pot. I don't know what it, because I've known, I don't like drugs at all. Don't believe in drugs. I like my brain. I don't want to get dumber. I never want to be a liberal. So, I just have an issue with the whole drug thing. But it's your body. Do it. I smoke. I drink. Whatever. But the thing about pot smokers is pot's a god to pot smokers. I don't know why. They'll give up their kids, they'll give up their spouses, they'll give up their homes, don't take their pot. That's all right. That's their issue. But if you were to walk into a courtroom and you're busted with pot, and the jury was a bunch of leftover hippies from the 60s all still smoking pot, do you think there's any way in hell you're going to get convicted? No. So the courts have said, well, we're just going to violate this rule that says a jury gets to decide about the law too. They really do. A jury can say, yes, we know that law is there, we don't friggin' like it. So, even though you did violate that law, we don't consider the law any good, not guilty. It could actually come back with a finding of innocence. Not likely, but it could happen. So, the way courts operate, the law notwithstanding, the rules notwithstanding, the way the courts operate is the judge is the trier of law. In other words, he reads the law, explains to you his interpretation of the law, and that that matter, that court proceeding is just going to have to go with that. Now, it oftentimes gets turned over on appeal because the judge is just wrong. Judges are wrong a lot in their interpretation of the law, quite often. When you read appeals, if you ever want to do kind of a, did anybody see the movie Judge Roy Bean, The Life and Times of Judge Roy Bean?
Yep.
Okay, it's an older movie. It was based liberally on a judge known as Judge Parker. Judge Parker, the time and the scenario was pretty accurate. The place wasn't very accurate. But The Life and Times of Judge Roy Bean was based on a man named Judge Parker, who was the most overturned judge in U.S. history. Parker cases of the late 1800s when the Supreme Court get them, they overturned like 32 cases in 4 years or something. This guy was just silly. He's like, if you're not a judge, you need to be hung. I mean, that was pretty much his ruling. So, and part of what he did was he just misinterpreted the law. Well, the judge interprets the law. Right, wrong, or indifferent, that's what he does. Whether or not it's his job, that's what he does. You're just going to have to deal with that in court. The jury is the trier of fact. Now, you've got to understand really what facts means and what trier means. In other words, if somebody takes the stand, and it doesn't matter if they put in evidence, doesn't matter if they put in an affidavit, the jury gets to determine whether or not that person's telling the truth. Has nothing to do with whether or not they are telling the truth. Has nothing to do with the evidence. The jury just look over there and says, well, we think he is or isn't telling the truth. They're the trier of facts. Is that a true fact? Is it not a true fact? Does it apply? Doesn't apply? So if you don't have a jury, who is the trier of fact?
Judge.
Nobody. Nobody. There is no trier. The judge is not a trier of fact. He's a trier of law. So unless you do what's called a bench trial, where you voluntarily forsake the jury, then you're allowing the judge to act as a jury and a judge. But if they deny a jury, then there is no trier of fact. So whatever the bank says is fact. Why do you think that is? Why is it whatever the bank says is fact and whatever you say is a lie? Why is that?
Presumption.
Exactly. The presumption that has always been in there. So remember, the forcible detainer is separate from the foreclosure. And the foreclosure, yeah, John.
I have a question on that case that we just went through with the lawyer. The judge said, oh, this isn't about the title, it's about possession. And then the lawyer goes up there and hands him a deed, right?
Yeah.
And the fact that they didn't object to it, does that mean that that's a valid deed now? Have they basically ratified that or said, okay, yeah, that's,
Okay.
yeah, deed's to and correct?
The other attorney should have objected to that. And the objection should have been, objection. This is not about the title or the deed. This is about possession. The judge had just said it. And now the judge undid it to help the bank.
Right.
Doesn't even make sense, does it? Because there is no determination of fact. He just gives that to the judge. This is a fact. That's it. And because of the presumption, now it stands as fact. Now, where the attorney went wrong just right out the door was he allowed it to continue.